by the judge.
Yes, his question is, did daughter get any notification? Yes, but by the time daughter received notification, it is too late already. That's too late. The box cannot be opened anymore. The box being attached by the bank. The bank,
So she cannot ask the.
No, until you pay off this $6,000. Yes.
Then that's fair.
Yeah, this is fair. I know that.
Fair.
Theoretically, this is fair, but for daughter, it's not fair, right? It's fair for the mom and the bank. You understand?
At least she can get it back as long as the mother pay off.
I mean,
right?
it's fair for the bank. I mean, but it's unfair for the daughter because daughter say, "Hey, mom, you don't have anything in my box, and you force me to pay you on behalf you to pay $6,000. Otherwise, my box value $100,000. I cannot use anymore." So
that's a problem.
at one side it's fair between mom and the bank, but the other side is unfair or surprise for daughter. So it really depends on which side you really. But again, go back to our important line. For legal matter or say business law, there is no absolutely fair or unfair. This is why you can argue, right? And say for this case it's fair. It's really fair between mom and the lender because lender get the money back, and that's what the judgment for, right? The bank spends so much money, go after mom, and finally get the debt paid off. That's fair, I understand. But it's unfair for daughter. If you want daughter, you'll say unfair.
So what if you have a safety box with a certain bank and the bank goes bankrupt?
Oh! Everybody heard this questions? Yes. What if you open up with the bank, the safety box with certain bank, and the bank bankrupt or closed down? Wow, this kind of thing happened in the third world, right? Or in any other undeveloped country. But luckily, we are in the United States. Luckily, for any bank, okay, FDIC, right? Is that called FDIC? If the bank is under the system FDIC and under the 100, I believe they raised the money, 300,000, right?
250.
No cash.
350, right?
Yeah.
Yeah, that's good.
Cash account is 100. Other is 20.
As long as this bank is under the FDIC, so every time when you open up the account, making sure this bank is under, I think 99%, I would say 99% the bank you in this area, they are under the FDIC protection, okay? So if the bank for any reason closed down, it does not happen too much. Even though in the past few years so many banks closed, World Saving closed, Washington Saving closed, so many closed, but luckily they are purchased, they are merged by the bigger bank. But really that happened, the government gonna pay off. The cash account is 100,000. For safety box, I believe is 350. Hopefully, yes.
So I have a question. So I don't know if this is still right. When you do a joint account, they always ask you your name and or your name or. Does it make any difference in that case?
Yes. Her question is if for joint account, what's the difference between A and B or A or B, right? Really depends. Okay, A and B really mean without AB's signature, nobody can touch the fund. Or mean one person, either or.
Just can touch.
Yeah,
But in that
yeah.
case, like if the mom owes the money,
Yes.
the and or doesn't matter.
That doesn't matter. For the creditor, it doesn't matter. Yeah, the question in the back.
I was going to say on the safety deposit box, because I work for Chase, the safety deposit box.
Still work for Chase right now?
Yeah.
Good for you. Officer,
Maybe not.
have a mercy for our student.
So the safety deposit boxes are not FDIC insured.
I don't
so
know.
It's property of
Yeah.
the owner of
Yes,
the box. So
yes.
if the bank closed down,
Yeah.
you can just go in and
Just
take
gone,
it.
right? It's gone, right?
They don't
Yeah.
insure contents.
Could be right because that's good, very good answer because safety box is not the bank assets, it's your assets. So there's another issue. When you open out the safety box, consider this because if the bank for any reason close it down, you lose everything. But if insurance. If you have insurance, and so that I believe that's the insurance issue. You better off have the insurance policy cover the item you put in the safety box. So this is why I want to spend a little bit of time about the safety box. Because when we open the safety box, we only consider safety. But don't forget, it's a risk there. There's a risk. So some people say change the name, risk box. Am I right? Change the name. So there's a risk box. Okay. So consider. Any other questions before we leave this issue? Yeah, because when we talk about personal property, only personal property we can put in the safety box, right? So it's very popular, and it's our daily life, part of daily life. Well, don't forget this risk related.
For example, if the bank got something wrong, fire or something.
Oh yeah, same thing.
Same
Same thing. I believe, right. This is really your insurance issue. Everything before you consider put into the safety box. Okay, every time. Without this class, probably you really think this is safety place, but not really true. Not really true. You take your risk, because this bellman, you trust this bank as a god, right? As a god, protect your assets. But don't forget, there's a risk there. Thief, fire, any other thing.
If the bank got robbed, you still lost everything.
Something, anything.
The
So,
insurance is only by yourself, not by the bank.
right. You take the risk. You take the whole risk. Okay, so keep this always in your mind. Always in your mind. Any other issue so far? Okay, we'll talk about another thing called statute of frauds. Statute of frauds. We may talk about this issue again. Eventually, this is one issue I left out last time. Okay, I left out from last time. Remember last time we were talking about contract, right? And statute of frauds. Once in a while you heard about this. Statute of frauds is a name carried over from an ancient law from UK, from British. I believe this is 16 something, so almost like 400, more than around 400 years old. Okay, there's one law passed in the British, and under this law or under that law, okay, require certain contract, certain matters must be in writing. Must be in writing, okay. And due to the time limit, the last time I left this issue out. Okay. Give you one example. If this contract is personal property, okay. Sales contract, for example. If the value of the item is more than $500 US dollar, okay, more than $500 US dollar, and the contract must be in writing. Okay, otherwise the contract may become unenforceable. Be careful, unenforceable. It is not void. Okay, be careful. Unenforceable contract still is good contract. It is still valid contract. I will explain to you what is unenforceable.